All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated.
Ladies and gentlemen, this case is about to get messy. We got a father fighting for financial support, a mother who's completely MIA, and a troubled teenager caught in the middle of MR. Thorne came to court expecting fairness, but will the law be on his side? The real question is, does he actually have a case, or is he about to hit a legal brick wall? Let's dive in.
Mr. Thornton?
Yes, ma'am.
You're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well...
Okay, let's pause here. Right off the bat, we see Mr. Thorne is in high spirits. And can you blame him? He's raising his son alone, and now he's drowning in legal and medical expenses. But here's the kicker. He agreed to no child support and mediation. The law is all about structure, and unless he can prove a significant change in circumstances, this case is looking shaky. What do you think? Should a parent still be held accountable financially, even if they moved away? Let us know in the comments.
He's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
if I remember correctly, you guys agreed to no child support during mediation.
Yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you.
Yes, ma'am.
And you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
Okay.
In that aspect. And, the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to...
But AJ was double insured by both of you, right?
Yes.
Okay, here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support...
Whoa, pause. Did y'all catch that? We're not just dealing with unpaid child support here. We're talking about a full-blown criminal situation. AJ is getting into some serious trouble, and now his dad is stuck footing the bill. The worst part? Insurance companies don't play when it comes to criminal acts. Oh, not only is Mr. Thorne drowning in expenses, but his insurance might drop him altogether. What would you do in this situation? Let AJ fend for himself or keep fighting for help?
There has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean...
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand.
And here's where things take a turn for the worst at MR. Thorne is hoping for relief. But Texas law isn't making this easy in the court's eyes. Nothing has really changed, at least not in a way that legally justifies modifying child support. Mediation agreements are binding, and unless there's proof of a major shift in living arrangements, income, or the child's needs, the judge's hands are tied. But let's be real, shouldn't a parent still contribute when their child is in crisis? Sound off below.
I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is
Honor.
there anything further?
No, ma'am. Not at this time.
Okay.
That's about it.
Okay, well, if there's nothing further, you're dismissed.
Thank you.
You're welcome.
Yikes. That's the sound of reality hitting like a ton of bricks at MR. Thorne was hoping for some relief, but the law is clear. An agreement is an agreement. Mom may not be totally off the hook morally, but legally, she's not obligated to pay a dime. This is one of those tough situations where fairness and legality don't always line up. What do you think? Should the law be more flexible in cases like this?
I just wanted to go over what you all witnessed in the Thornton case. Dad was appearing in court for the first time. He and mom settled at mediation for no child support. Well, now he wants mom to pay child support. Well, under Texas law, in order to modify child support, there has to be a material and substantial change. For example, there has to be a change in the child's mental needs, educational needs, a relocation of the parent, or an increase of income. None of those things took place in this particular case. Everything pretty much remained the same. Therefore, he was unable to get any child support from mom.
And that's it. Case closed. Despite the chaos, the ruling stays firm. No material change, no child support. This is a tough lesson in legal agreements. Once you sign that dotted line, getting a do-over isn't easy to so. Was justice served today? Or do you think the system failed Mr. Thorne? Drop your thoughts in the comments. Hit that like button if you found this case eye-opening. And subscribe for more jaw-dropping courtroom drama. See you in the next one.